Okay, thank you very much for coming. Today we'll be talking about the EU's sanctions on Iran in particular. As you all know, the sanctions that have been placed on Iran are intended to encourage Iran to return to the negotiating table. And initially, the EU has always been one step behind the US in terms of when it came to punitive measures on Iran, but it has done a good job of catching up and stepping up its game. Most notably, the sanctions on the energy sector, including the embargo of Iranian crude oil, and in the latest round, the sanctions on things like natural gas, for example, and of course the financial measures and sanctions related to the provision of insurance. All of these, I'm hoping that my two guests will touch upon in order to explain a little bit more what these sanctions are about and what impact they have. So with us today, we have two experts. Mr. Nigel Kushner is CEO of W Legal Limited, which is a law firm based here in London. His expertise is in international trade, including sanctions and export controls. And Ms. Natasha de Terán is head of public affairs at SWIFT, and she's in charge of government, institutional, and political relations globally for SWIFT. And I think we'll start with you, Nigel. Go right ahead.
Thanks. Okay. Good morning. Thank you to Dina for inviting Natasha and I to take part today. It's a privilege to speak for such a prestigious organisation. I often find that when I speak, I learn as much from the audience as I hope that you will all learn from me. So I look forward to hearing your thoughts in the general discussion. I'm here to provide an overview of the EU sanctions regimes on Iran. But I'd like to preface that overview with a few initial thoughts. I'm not a diplomat, I'm not a politician, I'm a lawyer. And my job is to advise those who instruct me as to what they can do and what they cannot do. I act for banks, insurers, ship owners, manufacturers, exporters, traders, and middlemen. I advise on deal structures, payment problems. I put policies and procedures in place for compliance purposes, and I conduct sanctions compliance audits. Much of my work involves advising on what the EU regulation actually says. Parts are very, very clear, but there's a number of significant grey areas. How do I deal with that? We have in the UK an incredibly hard-working and transparent set of government departments in BIS and Her Majesty's Treasury. If you ask them a question on the interpretation of the sanctions and don't drive them too mad, then they do give you an answer on those grey areas, a yes or no. We're very fortunate. In many other countries, you hit a brick wall in obtaining clarification from government agencies, and lawyers end up providing lengthy legal opinions, not answering the question, full of caveats, and the client pays a fortune for that privilege. I'm lucky, I don't need to do that. My firm advice to clients who are involved in Iran is to be fully transparent with the relevant authorities. If the transaction is legal, don't be afraid. If you've told HM Treasury what you're going to do and how you're going to do it, and they give their blessing, you couldn't really put yourself in a more favourable position. As I summarise the EU sanctions regime, I'll try to elaborate on some of the practical issues which arise. I see what's happening on the ground, who is continuing business, how they are continuing this business, and the challenges that they face. The real problems are twofold. Firstly, Iranians are finding it difficult to pay when the rial is decimated and hard currency is hard to come by. They agree a contract, they receive the goods, but by the time they need to pay, the rial has halved in value and it costs them twice as much to now pay. Secondly, even though a bank outside the UK, but in the EU, can legitimately receive payment from a non-sanctioned Iranian bank, it's near impossible to find one willing to do so, even if the goods are for a humanitarian use. The banks are terrified. They're legally permitted to do it, but save for a handful of banks who may do it for select customers, in general, they don't. The UK, the US, and the EU continually emphasize they don't wish to prevent trade in humanitarian or other exempt products. But the reality is this is not happening on the ground. Ironically, perhaps, it's actually easier to transact in exempt goods from the US than from the UK. Indeed, US exports to Iran have increased by some 30% so far this year. My view, and this is just my personal perspective, is that perhaps HM Treasury or the EU should work with and nominate one non-Iranian bank who they like and trust, who may receive payments from non-sanctioned Iranian banks for legitimate purposes. Transparency is surely better than driving payments underground and through money exchanges. Better education by EU governments will help. It's difficult to throw repeated, complex rules out and expect immediate compliance. The British government is trying, but is no doubt constrained, like much of the rest of industry, by budget cuts. It's difficult to be involved in Iranian business without trying to understand the background politics. The future sanctions regime may depend on how that background politics plays out. We have Obama having won the US election. That's relevant. Equally relevant will be the outcome of forthcoming elections in Israel and Iran. I'm only going to focus on EU sanctions, but for anyone involved in Iranian trade, it's crucial to consider US sanctions, UN sanctions, unilateral UK sanctions, and something people often forget, Iranian sanctions. For example, Iran recently banned the export of some 50 items of product. This has had major repercussions, particularly for those in the EU who are getting paid through barter deals. They're not receiving cash, they're receiving product, but now they can't even get that. Please bear in mind that EU sanctions are only one piece in the sanctions jigsaw. In terms of EU trade with Iran, I see a number of big players exiting Iranian business, whether as a result of sanctions or informal political pressure. But most of the big players have remained. They have the resources to think outside of the box and continue their business legitimately, although there are exceptions where they continue their business in a manner which, in my opinion, does breach sanctions from time to time. At the lower end, the smaller players are doing one of three things. Most are exiting the market because they lack the resources and the wherewithal to continue. Others continue in blissful ignorance. They're just not aware of the sanctions regime or don't take them seriously. Then we have a hardcore minority who continue to trade knowing they are breaching the sanctions regime. They tend not to come through my office door, and if they do, they're out very quickly and are told in no uncertain terms they risk going to jail, which frankly is exactly where they should be. By and large, Iranians are still getting what they want, although it may take longer and they may have to pay more. Speedboats across the Gulf are rife today. Turkey's economy is booming, and they are a beneficiary of the sanctions, given they're outside of the EU. Iran wants European products, in particular German products. If they can't get them, then China will gladly step in and supply. China is, I suspect, delighted. They're doing nothing wrong and can walk into a lucrative market. Now, before I go through the slides briefly, let me tell you about a rumor I heard a few weeks ago. I'll share it with you, but please keep it quiet. I heard a rumor that the EU member states were one big happy family, always acting in unison and never disagreeing. Now, we all know that's not the case, but when it comes to sanctions on Iran, the EU have been incredibly unified. There have been a few examples of national self-interest taking precedence. We've seen the UK concerned about the impact on its insurance industry. We've seen a Scandinavian country allegedly angry about prohibitions on its telecoms industry. We've seen a small number of former EU purchasers of Iranian crude very unhappy. But by and large, the EU has been incredibly robust and unified in its mission to step up sanctions on Iran time and again. I would go so far as to say it is unprecedented. So, an overview of the sanctions. This all comes down to Regulation 267/2012, which entered into force on March the 24th, I believe, this year. This regulation summarizes all the prohibitions and restrictions on Iran trade It's shortly going to be updated in line with a new decision that came out on the 15th of October. That's decision 2012-635, which we're going to go through. Now, save for the asset freeze provisions in that decision, this decision, although binding on member states, is not binding on individuals and companies in the EU yet. We don't know when it's going to come into force. It could be tomorrow, it could be next month, it could be next year. In the UK, HM Treasury deals with the financial sanctions that relates to payments and the asset freeze, and BIS, through the ECO, the Export Control Organisation, deals with what is prohibited or what is restricted in terms of products that can be supplied to Iran. All EU nationals, wherever they are in the world, must comply with the sanctions. There is an exposure, which we're going to see in a few moments, for EU nationals who are directors of overseas subsidiaries who have dealings with Iran. What do you need to check if you're exporting goods, or if you're a bank, or if you are an insurer? Are there any restrictions on the goods? Are there any restrictions on the entities and banks who are involved in the deal? Are any of them subject to an asset freeze? Do you need authorization to receive or make payments? Are there any restrictions on insurance and shipping? So let's look at the goods. Question 1, if you're exporting or involved in financing or insuring an export, are the goods prohibited? Now remember, your goods may have a humanitarian use, but if they're on the list, you can't ship them. For example, there may be a pump, which is defined as a key item for the oil and gas industry. If that pump is on the list, you can't export it to Iran, even if it's going to build a well in a small village somewhere. It doesn't matter what the use is. If the product's on the list, you cannot export it. Always get a license from BIS if you're exporting from the UK. That itself has many challenges, because let's imagine you're a manufacturer or an exporter. You get an order in for Iran for some goods. You're not going to agree that order until BIS have said, yes, I'm giving you a license, or no license is required. We give you what is called an NLR. Now, that license is only good for the day it's given. Now, you then go on to manufacture the goods and ship them. You come to ship them 3 months later, and if during that period, if during the time after that license was granted, BIS have decided that some new goods are on the list, or that they don't like the end user, that's it. You can't ship the goods. And I've actually seen an example, a sad example, of a UK manufacturer go bankrupt. They'd shipped the same goods time and again to Iran. They were always told no license was required. But after getting their license in the last deal, they were told at the time of shipment, sorry, we've changed our mind. We don't like the end user. We can't tell you why we don't like the end user, because that's classified, but you cannot ship these goods. Those goods were bespoke. You can't ship them to anywhere else. The English manufacturer had spent hundreds of thousands of pounds making these goods. They went bankrupt. So what are the prohibited goods? Nuclear, WMD, military goods, unsurprising, dual-use goods. Goods that can have a perfectly legitimate use but could also be misused. Goods that can be used for internal repression. Be careful, this could include satellite phones. We had an incident in Syria recently where an English company gave all its employees satellite phones, but they were on the list of prohibited products. Again, it doesn't matter what the use is. Key items for the oil and gas or petrochemical industry, crude oil or petrochemicals, gold, silver, diamonds, and other precious metals. What's going to be added? They're not added yet, but it's going to be natural gas. Now remember, people are saying in the press natural gas doesn't matter. Who in the EU imports Iranian natural gas? Well, the answer might be no one, but it does have an impact. Who's shipping it? Who's insuring it? Who's financing it? All of that is now going to stop. Graphite, raw or semi-finished metals, such as aluminium and steel. Now, we don't know what the final list is going to comprise. So I've got clients coming to me now saying, Nigel, I've got this great contract in for some steel billets. Do you know if it's going to go on the list? I don't know. I have no idea. I don't know if the EU even know whether it's going to be on the list. So what do? They're allowed to perform that contract if it was entered into before the date of the decision. So they're taking a risk. They can sign a contract now, it's for delivery in 3 months, But if during that time the regulation comes out and steel billets are on the list, they're in big trouble and they cannot perform that contract. What else is going to be on? We've got key naval equipment and technology for shipbuilding, maintenance or refit. We've got software for integrating industrial processes. We've got the provision of flagging and classification services for Iranian vessels. We've got the supply of vessels for transport or storage of oil or petrochemical products. And finally, services relating to the construction of new oil tankers. You've always got to check if you are a bank, insurer, or any way involved in Iranian trade. If you're in the EU, check the customer, the agent, the end user, everyone in the supply chain. Check they're not subject to the asset freeze. If they are, don't touch the deal. What do people do to check? They might use something called IISS, which is a system organized by Thomson Reuters. There's lots of other similar systems. They're very good. You put in the name of a person, a ship, or a company, and you print out a little certificate which tells you whether it's on the asset freeze or not. So everyone thinks, that's great, I've got my little certificate, I can go ahead and do the deal. No, you can't. You can get caught. See why you get caught. Read the regulation. No funds or economic resources shall be made available directly or indirectly to or for the benefit of someone on the asset freeze list. So, I've got an example here of a company called IISS Steel. A while back, a Mr. IISS in Egypt was placed on the asset freeze list. Okay? He happens to be the chairman and a shareholder in a company called IISS Steel. So, my client has a shipment of goods to IISS Steel, and they put IISS Steel in the list. It's going to come up clean because they're not on the list. But actually, they would be breaching the regulation in shipping product to IISS Steel because as a result of that, it will result in funds being made available indirectly for the benefit of Mr. IISS. So you've got to be really careful, and the banks need a lot of education, and a lot of them are relying on these lists and actually unwittingly breaching the sanctions. Again, mere business bank. It's part of Bank Melli. No one in the EU can have dealings with this bank, but for some reason, I don't know why, it's not on the EU sanctions list. But if you look on the Bank Melli website, it's very clear that there is an ownership interest on the part of Bank Melli with mere business bank. Finally, check the Iran list. That's a UK list of people the UK don't like very much, and they would like to be notified if you have dealings with them. It's not automatically the case that you won't be able to have dealings with them, but you should let the authorities know. What about transferring funds? Okay, you've done your deal, you've jumped through all the hoops with the goods and all the people in the supply chain. Okay, then it comes to payments. If anyone in the EU receives money from or pays money to an Iranian person, entity or body, then you've got to jump through some hoops, unless it's less than 10,000 euros, in which case it's permitted. Don't try to be smart if you've got a 20,000 euro payment and make 2 payments. That is in breach of the regulation, that's circumvention. You've got to notify the authorities if it's between 10 and 40,000 euros, and you've got to apply for an authorization if it's above 40,000 euros. Now, this can be very problematic. You've got to give 4 weeks advance notice. How many people, when you're expecting a payment from someone who doesn't really have the ability to pay you because they're not very rich at the moment, can tell you 4 weeks in advance which bank they're going to use, all the banking information, and allow you to notify Treasury and then wait for a response? It just doesn't happen in practice. Okay? Now, the obligation is on the bank to notify or seek authorization. If the bank is in the EU, the obligation flips. It switches to the payer or beneficiary in the EU if the bank is outside the EU. So what has been happening until recently, okay, is that no UK banks will allow its customers to receive payments from Iran. Now, let's imagine the bog standard method of working. You have an English company. It has a subsidiary in Turkey or Dubai or Singapore. It's selling goods to its subsidiary, and then its subsidiary sells those goods onto the Iranian customer. The Iranian customer makes the payment to the subsidiary in Turkey or Singapore, for example, and then the payment comes from a nice Singapore or Turkish bank into Barclays Bank PLC, for example. Now, if the customer says to Barclays, I'm receiving this money, it's coming directly from Iran, Barclays will likely close that bank account. But because the authorization request required, which is the obligation of Barclays Bank, can be made on behalf of Barclays Bank, the beneficiary, the English seller who sold the goods, is making that application on behalf of Barclays Bank to Treasury, saying, "Dear Treasury, we're receiving this payment into Barclays Bank. It's coming from a nice Turkish bank account. No one would really know it's coming from Iran, because why would you? But we're letting you know because the bank's got to let you know." The bank doesn't know. And all these payments have been going through traditionally. Now, since March 26, 2012, funds transfers includes cash, checks, and even shares. What do the new rules say? The new rules have an impact on financial institutions in member states in relation to transactions with banks in Iran, which includes the CBI, and their branches and subsidiaries worldwide, and financial entities not domiciled in Iran, but controlled by Iran. That may well include all the money exchanges outside Iran that are controlled or owned by Iranians. It's not clear how linked transactions will be dealt with. There's going to be two hoops that these banks need to jump through. First of all, the transaction itself has got to be authorized, but that should be plain sailing because it effectively includes all transactions in connection with a specified trade contract, which is not prohibited under the decision. So it's everything that's not allowed. That should be straightforward. They then need to obtain authorization prior to a funds transfer to and from Iran using Iranian banks and financial institutions. The authorization and notification requirements are very similar. I'm not going to go into those. Let's very briefly look at the definition of an Iranian person, entity, or body. The definition of an Iranian person, entity, or body includes any natural person in or resident in Iran. So if any of you happen to be on business in Iran, strictly speaking, you cannot receive a payment or make a payment over 10,000 euros whilst you're there. What about an Iranian resident who happens to travel overseas a lot? We need to look at a number of criteria, which is listed there, to determine whether or not they get caught. There's a bigger problem. An English company, which is owned or controlled by an Iranian person or an Iranian company, is also caught. They simply can't function anymore. So if there is a company with a 70% Iranian shareholder, that English company cannot make any payments over 10,000 euros without seeking notification or making an authorization request. I've seen English companies try to pay their VAT bill and it gets rejected, even if they've got authorization, because the bankers of HMRC, don't want to receive the money from an Iranian company, even though it's an English limited company. So that creates a lot of practical difficulties. What about non-EU subsidiaries of English companies? We talked about an English company having a subsidiary in Turkey, for example. It sells its products on an arm's length basis historically to its Turkish subsidiary, and the Turkish subsidiary sells those products into Iran independently. Now, interestingly, that non-EU subsidiary, the Turkish subsidiary, is permitted to receive payment from a sanctioned bank, and that won't place the English parent company in breach of the regulation. It goes further. The English company can even provide certain back office services to its Turkish subsidiary. It can arrange shipment. It can even possibly review the LC from the sanctioned bank without being in breach. But of course, authorization should always be obtained before monies are sent to the English company. Remember, the English company can always notify Treasury on behalf of its bank. Be careful. EU nationals who are directors of the non-EU subsidiary in Turkey face personal exposure if a payment comes in from a sanctioned bank, even if they extricate themselves from the business and have nothing to do with it. The way the sanctions regulations are interpreted, if you could have done something but stood back and allowed it to happen as a director of that company, you could go to jail. Insurance issues, big difficulties faced by Iranian companies who hold property assets in the United Kingdom. They're not allowed to get buildings or contents insurance from an EU insurer. Simple as that. Doesn't apply to natural persons, and it doesn't apply to compulsory insurance or third-party insurance. But buildings insurance doesn't really fall within that. There's a lot of buildings in central London that are currently uninsured, and there's probably even more that are insured in breach of the regulation. Do the insurers really know that an English company who owns a building which is owned by an Iranian or an Iranian company? They don't. They just go ahead and insure it. And one of the jobs is to educate insurers as to what they can do to check. Big difficulties faced by the shipping and insurance industry. It's prohibited to insure the transport of crude oil and petroleum products. That's traditionally insured in the London insurance market. Now the Japanese, the Indians, and the Russians are talking about insuring those cargoes themselves. So the London market is losing business. It could get even worse. Once these other countries understand how the business works, they might pitch for more general cargo insurance in the shipping industry. Finally, we're nearly finished, the unilateral UK sanctions. Very important. Forget the EU sanctions. Since late 2011, no UK bank can have any dealings with any Iranian bank, whether it's on the sanctions list or not, including through one or more intermediaries. So going back to our example, English company sells goods to its Turkish subsidiary sells it on to Iran, Iran pays through a non-sanctioned bank, all perfectly legitimate. Turkey cannot pay those monies to a UK bank. What is the solution? The solution is for the UK seller to receive the monies in a bank account outside of the UK. That's the way that I'm advising clients to do business in the traditional, legitimate manner. They still need to apply for authorization. But there's also a problem. Let's imagine that Turkish subsidiary who receives money from the Iranian bank. Clearly, it can't do a pass-through payment to a UK bank, but what if it's receiving 100 payments through the year of $1 million each, and only one of them comes from an Iranian bank? Can it transfer any money up the chain to its parent? I've asked Treasury that question, and they haven't given an answer, probably because they know it's impractical and possibly ridiculous to say, no, you can't pass anything, but nor do they want to stick their head above the parapet and say, yes, that's absolutely fine. But that's very interesting. Abuse of contractual provisions. Everyone's putting these wonderful clauses in contracts today, relieving themselves of liability if they can't perform a contract because of sanctions. But it can backfire. It's being misused. There's a couple of examples here. I'm not going to go through them in detail. But the second one, this was between a Russian company and a Chinese company. What are they doing? They're agreeing to comply with US sanctions as if they were applicable to them, which means they can't have any dealings with Cuba or Burma or lots of countries where they probably regularly trade with. Prepayments is an issue. A lot of Iranian companies have made prepayments to English companies for goods. They then get a nice letter from the English company 6 months later saying, sorry, we can't give you the goods because we're not allowed to give you them anymore. Iranian company says, well, not very happy about that, but can we have our €1 million prepayment back? English company says, sorry, you can't. Read the contract. And in English law, a contract says what it says, and those contracts usually have clauses which say something like, if we are prevented from performing the contract, then we don't need to, we won't be liable, and if you've made us a prepayment and we've started spending money manufacturing the goods, we don't need to give you it back. An appropriate place to end, penalties. A company incorporated in the EU will be liable for a breach. The directors may be liable for the actions of the company if the offence was committed with the consent or connivance of the directors. Any EU national anywhere in the world can be liable, potentially up to 2 years in prison and an unlimited fine.